Hello boys and girls, my name is Parthiban. I will be handling political science and legal studies for you through this YouTube channel. I have 6 years of experience in teaching political science and legal studies. The purpose of starting this YouTube channel is that I just found out that there was no YouTube channel that were teaching these two subjects in English. Mostly it was in Hindi, so I just wanted to make sure that you also have these concepts and subjects available in English. So I will be completely teaching you these two subjects for both 11th and 12th in English, and we will cover units by units, and we will divide the units into various parts, and then we will discuss in each videos. So firstly, I will just like to start with legal studies unit 1. As you can see, so we'll first see the judiciary chapter, and in judiciary chapter we will be basically looking about the basic things in judiciary, like we'll be discussing about the Supreme Courts, High Courts, and subordinate courts, and how things were happening in India. So let's start with how was the judiciary during the British India. As you can see, the Supreme Court came into establishment in the year 1950. So how was the judicial system before the independence, during the British rule, was that we had federal courts and we also had privy council. So the federal courts is considered to be the highest courts in India, which is present in New Delhi, which is present in British India, and that's the highest court in India. But if you wanted to go further to get, if you want to go further for an appeal, you can also go to privy council, which is what you can see in the picture, like that's a privy council which is in London, and that's the final that's a final appeal that you can go. That's considered to be the apex court during the British time. So this federal courts, and which was there in British India, was formed from the Government of India Act 1935. So you would have been you would be seeing this in class 11. So we'll come to that later, where I will also give you videos about the basic things in the political science, which we see about Government of India Act in 1935 in class 11 political science. We'll come to that, but just for an introduction purpose, I'm just telling you that this is how it was. We had federal courts in India and we have privy council, which was in London. But later, after the independence, after the constitution was framed, constitution talked about the Supreme Court, which came into establishment in 1950. So the above courts were abolished and Supreme Court came into being. So today, right now, if you see, after independence, we have Supreme Court, which is the apex court, and below that we have high courts. We have various high courts, and even below that we have district and subordinate courts, which is present in each state. So we'll be looking about these three things in detail in the upcoming slides. We'll be looking about in detail about the Supreme Court, High Court, and district and subordinate courts. So moving on to Supreme Court, as I said, the Supreme Court came into being in 28 January 1950. So, and it was started with only 7 judges and with 1 Chief Justice, and the Constitution also gave them, the Supreme Court, the power to expand the number of judges over a period of time. So currently, if you look, at present we have 34 judges, including the Chief Justice of India. Right now, the Chief Justice of India is Chief Justice Chandrachud. At the time we are speaking, I am recording this video. So this is about the Supreme Court. We will be seeing about the roles of Supreme Court bit later in the upcoming slides. We'll see. So to just give you an introduction, I think this is fine. It was initiated in the 28 January 1950, and at the time of starting there were only 7 judges and 1 Chief Justice, but currently we have 34 judges, including the Chief Justice of India. So now again, next moving on to High Courts. India consists of 25 High Courts at the state and at the union territory level. So the main work of High Courts is that High Courts have control over a particular state. Sometimes some High Courts may have control over 1 or more states, 1 or 2 states. So mostly we have high courts which takes control over, which takes jurisdictions over a particular state. Okay, and there were the 4 courts, as I mentioned. You can see Madras High Court, Bombay High Court, Calcutta High Court and Allahabad High Court are the first 4 high courts that were established in India, and these are the very old high courts that are present. And below the high courts we have the lower courts, which we will be seeing in the next slide. We have lower courts, and lower courts will look into the matters of civil and criminal cases, and also we have specialized tribunals. Tribunals, again we will be seeing about tribunals in the same chapter, which is also upcoming. So we will look about that, we will look about tribunals. And to give, since we are talking about tribunals, I will just like to give you one statement saying that tribunals are there to assist the courts, because the courts are today, it is overburdened and it has lot of pending cases. So in order to reduce the burden of the courts, we have tribunals which is in place, and tribunals are supplementing the role of courts. So you know that, and you see Andhra and Telangana high courts were the recent high courts that were formed in 2019 thing. So moving on to district and subordinate courts. So the district and subordinate courts are the courts that are below the high courts. You see, India has a federal government. You should be aware of what is a federal government. Federal government means that 2 or more governments is what we say the federal government. For example, in India we have central government, we have state government at the state, and we have local governments at the local level. So there are three governments. So the power sharing is divided between the center, states and the local. So this is federal. But you take judiciary, we have single integrated judiciary. You should be careful about the word that I say, single integrated judiciary, which means that it's the Supreme Court at the top, and whatever the Supreme Court says, all the subordinate courts, which means the high courts and the district courts and even below the district courts, has to follow what the Supreme Court has said. So even though there might be many different courts, but it is a single integrated court. Okay. So coming back to this slide, you can just see that the courts that function below the high courts are popularly known as the lower courts. We just call it the lower courts, and each state is divided into judicial districts. So we know, I'm sure all states have some districts, and each district has a court, and which is led by judges. We say it as district and sessions judge. Okay. And next, moving on to the district judge. Who is called a district judge and who is called a sessions judge? Now, the district judge is a judge who presides over a civil case. You know what is a civil case? Civil case is something that deals with property or money matters, is what we usually say it as a civil case. And sessions judge means that a judge who presides over a criminal case is known as the sessions judge. See, criminal cases means where you do a crime and there might be punishments like there might be imprisonment or something like that, is what we say it as sessions judge. So district judge and sessions judge. And sometimes we also have this judge called as metropolitan sessions judge. Metropolitan means that a judge who is presiding over a district court, and if that city is considered to be metropolitan, then the judge is called as metropolitan sessions judge. Okay. So again, now moving on, the district judges may have additional district judges depending upon the judicial workload, because see, nowadays the problem is that with India we have lot of population. With lot of population we have lot of cases, lot of pending cases. So with all these cases, it makes more and more difficult for the judiciary to just finish off the case and dispense them. So depending upon the workload, the district judges may appoint more additional district judges according to their workload. So the district judge is the highest judicial authority below a high court judge. So if you take Supreme Court judge, and who is more powerful next to Supreme Court judge is that it's the high court judge. So if you take the high court below a high court judge, it becomes a district judge who becomes the most the highermost judge below a high court thing. So moving on to district court also holds appellate jurisdiction, and supervision over all subordinate courts. See, here we are looking at a new word known as appellate jurisdiction. You should be aware now. By the time you are looking at this, I think your teacher would have taught you what is appellate. Appellate is where you go for another chance to the higher courts, asking to reconsider the decision. Sometimes it always happens. You see, whenever a judgment comes, judgment can be only in favor of one person, one party. But what if the other party who loses the case, where the judgment is not in favor of the party, the other party might go for an appeal. For example, a district court might give me a judgment which is not favorable towards me. So I am not happy with the judgment. So what I do is, with that case, I move on to high court. I move on to the higher court for appeal. So I am asking the courts to reconsider. I am asking them to reconsider the judgment that was given to me. So that is what we mean by appellate jurisdiction. So here when I say district courts also holds appellate jurisdiction, which means that the judgments that are given by the courts that are below the district courts, so now they can go to district court for appeal. So again, you should be knowing, like, what if the district courts gives you judgment and you are not happy with the district court judgment? Where do you go? You go to high court. So that is what we say, that district court also holds appellate jurisdiction and supervision over all the subordinate courts below it. See, in a district, there is no only one court. For example, in my area, let me say, in my area where it is considered to be district, but when it considered to be a district, many areas comes under it. Geographically looking at it, there are many areas comes under it. It's a very big area geographically. So small areas might have some courts to deal with matters that are present at the local level. So which court is responsible? The district court is responsible towards them. So it also supervises over all the subordinate courts, like how Supreme Court supervises high courts. The high court supervises all the district courts, and district court supervises all the subordinate courts below it. So this is how the judiciary works. So now even below that, you see civil side courts and criminal side courts. Now looking at the civil side courts, there are many different types of courts, which is junior civil judge court, principal junior civil judge court. That's the second thing, and last is senior civil judge court. And looking at the criminal side, we call that second class judicial magistrate court, first class judicial magistrate court, and chief judicial magistrate court is what we see. Okay, now moving on to the salient features of Indian judiciary. Salient features is nothing but the characteristics of Indian judiciary. So the first point says that India adopted British tradition of common law model. Okay, now here again we are looking at a new term known as common law. See, I'll again come back to the slide, but to explain about this common law model, I will move on to the next slide. You see here, there are two types of legal system in the world. The first is the common law system, and another one is civil law system, which I have highlighted in the first two things. You see, common law system and civil law system. These are the two systems that is available throughout the world. Any country you take, it have either adopted common law system or adopted a civil law system. So India have adopted common law system. Okay, why does India have adopted common law system? Means that the British who ruled us had followed this system. So when we got independence, we also took this particular system from them. So we also have common law today. So that is how India has adopted common law system, because the simple answer is British followed it, so as we. Okay. So below I've just mentioned you something known as adversarial model. Okay. So now what is adversarial model? Adversarial model is that, I'll come back to this because the next slide talks about that. Now moving on to civil law system. So civil law system is nothing but the main difference between the common law system and civil law system is that in common law system, the courts can make laws. Okay, that is a common law system. In civil law system, the courts can give only judgments, they cannot make laws. Okay, so this is what is the main difference between common law system and civil law system. An adversarial model and inquisitorial model is a model that is followed by common law. Inquisitorial model is followed by civil law. So I will explain again in detail. So now moving to adversarial system, you see in adversarial you develop their own theory of case and gather evidence to support their claim. For example, you take India. What happens in India? India follows adversarial model. Okay. So when you file a case, what do? You go, you file a case, you hire a lawyer and you tell your problem. you discuss with your lawyer and how to go get along with the cases, what all to discuss, what are the evidences, you discuss, and the lawyer helps you. The lawyer speaks in front of the judge, he argues for you, he provides the evidences. Based on the evidences, the judge gives a judgment. This is what is happening in India. So this is what is adversarial system. Now you look at this, develop their own theory of case. Who? The party. If I am the party, if I have filed a case, then I develop my own theory of case. I give my version of the problem. So along with the help of a lawyer. So and gather evidence to support my claim, support their claim. Na? So I say that, see, I have not done this. Na? I will give you all the evidences that supports that I have not done, I am not involved in this. I will give you evidences to support my statement. Now next is, parties are assisted by lawyers. As I said, the lawyers will assist. See, when you file a case, you cannot go and argue in case. That's not possible. There is a procedure for it. You should be knowing it. So you have to become a lawyer. You have to go to courts. You have to take up the exam. Only when you get enrolled yourself in the bar, and then only you can go to courts. So it's not just simply just like that, walking into courts and arguing with the judge based on your needs. It's not possible. So you need help of a lawyer. That's the second point. Third is cross-examination and scrutiny of evidences of opposite party. See, in Indian system has given a very good opportunity for you to cross-examine the evidences present by the opposite party, which means when opposite party gives an evidences against you, you have the right to cross-examine. And scrutiny is nothing but the meaning of scrutiny is checking. You can check whether the evidences are correct. You can check. You will be given the chance. Okay. And look at the fourth point, which is the role of judge is passive, as he decides only based on the evidences and arguments presented by the parties before him. So which means they are saying that the role of judge is quite minimum, which means when we say minimum, he does not see the judge just looks at the evidences. I will tell you one thing, even if you are not able to sufficiently prove that you are the criminal, then they cannot punish you. So only based on evidences, even if you've done a crime and if you're not able to prove, you will not be punished. So we have something like only based on the evidence should speak. If you don't have evidence, then you are in trouble. So only based on the evidences, the judges give judgments. Okay. And next is usually adopted in common law countries. Yeah, I said you earlier. And example is UK follows this model, USA follows this model, India follows this, and Australia follows this. Okay. Moving on to its advantages and disadvantages. Cross examination can be effective to check the credibility of the evidence. Yeah, when you cross check, then you know whether if they're really providing the true information, or whether if they're really providing something else to put you in trouble. You have that advantage to cross check. And also effective control over the process. Since you are the person who is deciding how this case should go, you discuss with the lawyer, you plot all the plan. So you are involved in the process. So that's an advantage for you in this adversarial model. And coming to disadvantages, the cost of justice. In the cost of justice, there is a lot of payments that you have to make. The document fees, the court fees, the advocate's fees. So all this costs you a lot. Okay. Second is the procedural the trade, which means that it takes a long time to process all such things, and it takes time, it delays the case. So this is an disadvantages again. And next is, as I said earlier, the judge plays a less active role. They only evaluate evidences, do not ascertain the truth. So even you may be, that's why I said you may be an innocent, but the evidence should speak. You may be a criminal, but the evidence should speak. Whatever the evidence says, only that will be taken into consideration. Okay. So next, moving on to inquisitorial model. So inquisitorial model is nothing but the role of a judge is active. It's just opposite. Okay. So as I said, in the common law, inquisitorial model is followed in common law system, where courts can make only judgments. They cannot make laws. That's what I said. So the role of judge is active here, and as he determines the facts and issues, unlike the adversarial model where the judge evaluates only the evidences. It's not like that here in the inquisitorial model. The judge gets into the shoes of investigator and he investigates the matter. Okay. So that's why the first point is saying the role of judge is active. He actively plays his role as a judge. as he determines the facts and issues. So the judge also decides the manner in which the evidence must be presented before the court. So the judge is having complete control over the case, and he decides everything, how the case should go on. Okay. So the third point is that the judge then evaluates the evidence present before him and decides upon the legal claim. So now, since I said, since he is getting into the shoes of an investigator, he acts like more like a policeman, and he investigates, and he will know what really happened. So based on that, he will say how evidence should be presented, and he will decide the matters. Okay. So next is this model of adjudication is also known as interventionist or investigative model. As I said, they investigate, they act as more like a policeman. So what do the policemen do? The police investigates. Likewise, the judges do in inquisitorial model. So where it is adopted now, it is adopted by civil law countries. Example, the European countries and all have adopt such things. Okay. So the advantages and disadvantages of this is that the active role of judges prevents delays. So unlike the adversarial model where you can delay the case, but that's not the case here. You can you can reduce the time of the judgment being given by the judge. So because the judge actually interferes in the case, and he decides how it should go. So that you can prevent delays. You can get judgment in a very short time. Okay. And second point is that equality between the parties. Judges cannot be influenced. So what if you take adversarial model, for example, you are filing a case and you are getting the best lawyer in the city, and because you have money, assume something like that, you have money and you are getting the best lawyer in the city. Your opponent, he does not have much money, and he is hiring a lawyer who is not well versed, all such things. Now again, this will influence in the sense the way he speaks, all these things will matter. And as of our system, only the evidence will speak. Evidence and the way your lawyer advocates for you, all that matters. But here it cannot be done. So judge cannot be influenced. Next is disadvantages. The disadvantage is that since the judge steps into the shoes of an investigator, they can no longer remain neutral to evaluate the case with an open mind. So a judge should be a judge. He should not be investigator, is what they say, is that disadvantages. And lack of incentive structure for judges in proper fact finding. Incentive structure means that they are talking about salary of the judges. They say that the judges are doing more work than the adversarial model, but the pay of judges is quite less because they get into the shoes of investigator, but they are not paid much, is what they are saying. So that is what they mean by lack of incentive structure for judges in proper fact finding. So guys, I think I will stop here for now, and then we will continue. Hello boys and girls, my name is Parthiban. I will be handling political science and legal studies for you through this YouTube channel.